Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman, and our next guest, a reporter needs no introduction, Mark Furman, director and shareholder at Tarlow, Hart Rodgers. Always a pleasure to see you and have you on Radio Entrepreneurs.
Nice to see you, Jonathan.
So, topic for today is something that perhaps many people don't do, and that is, I guess, heeding the warning signs and when things are perhaps going off track. In a legal sense, how to identify and be proactive. So do you want to talk a little bit about what you typically see, which is, the people not responding till the sirens are wailing and their hair's on fire?
Right. In almost every case I handled, Jonathan, there's a long, protracted email exchange, text exchange, and people assume that it's private. So they say things they would never put in a letter, and they don't assume that it's possible the other side's lawyers, a judge, and a jury's going to read it, usually some blown up version of it. So what you need to do is anticipate the possibility that people who you don't want to be reading this text or this email actually are going to read it. So how do you protect yourself? Well, one way is to get your lawyer involved early. The warning signs are, okay, you're going to terminate or thinking of terminating an employee. You're going to terminate or thinking of terminating a contractual relationship, which under which you may end up working with a competitor, for example. There's a myriad of situations where these emails and texts become important pieces of evidence. Nobody writes letters anymore to speak of, unlike when, a few years ago when I started practicing. But people write a lot of emails. And
chip. That was the stone and no, I'm just kidding.
Sorry, there's a misperception that these electronic communications are private. Of course, they're not.
That's what I was going to ask. In Discovery today, and I know because you've talked about this before, you spend a lot of time and a lot of energy, and as a result, a lot of money on electronic communication, forms of communication, whether it be text messages, voicemails, emails, and those are generally in the myriads. A lot of pages of that stuff ends up coming up in Discovery. And I think that's what you're alluding to, is that all of those things become part of a potential legal situation. And so very often better off consulting your attorney early, devising a strategy for responding, and limiting the amount of communication back and forth, because invariably those are the things that tend to trip people up later on in the legal process.
Yes, and because there's this perception that they're private, people are unusually candid about their feelings about other people. So if there's a claim that involves, well, what's the intent of a party that takes a particular action, texts and emails might be a beautiful vehicle for the other side to show some type of allegedly wrongful intent based upon something that was said or included in a text or an email. So getting advice early, I think, is important, not assuming that every business transition or transition from an employee moving on is going to be smoothly and unchallenged. many are, but a lot of times the cost of litigation can be even greater than the exposure in the litigation. So it's all about how do we prevent litigation. And one thing that lawyers try to do for their clients when they're engaged early enough is to prevent litigation and and minimize the risk to the client in the event there is a dispute. It's no different if it's an arbitration or an actual lawsuit. Um, you know, there's an old saying which is escaping me for the moment about never speak when you can nod, or never write something when you can speak. I forget the precise phraseology, but it's that idea. It's just the protecting your risk is really what advisors generally are trying to help people do, whether it's in your line of work, Jonathan, in terms of consulting with businesses, or what lawyers are trying to do, or insurance experts. They're trying to help clients manage risk. But I do think there's a resistance among some businesses to getting legal advice because it's perceived as an expense.
Yeah,
And
I wonder whether it's the expense. That was the question I was going to ask you. Is it the expense associated with it, which may sometimes be the case? And I think, the point that you made earlier is probably often the case. Oh, it's not a big deal. People sort of, shrug it off to, well, it's not a big deal. And then something that you think is going to be settled in a day or a couple of texts back and forth takes on a life of its own and quickly mushrooms out of control.
well, I think it could be, you know, people are not aware that they're um, taking actions that could be criticized by another party, and that we have a system of how those uh, criticisms, which become disputes, get resolved. And I just, so I do think that's part of it, but I also think there's a resistance to incurring the expense um, of getting a lawyer up to speed, having him or her review the deal documents, understanding what the contractual, legal, statutory obligations are, and then working with the client on making sure that the communications are protective of the client. So it can be a little time consuming, but again, it's a drop in the ocean compared to the cost of full-blown litigation.
So this is another one of those cases where we could use another oft-used phrase: "Penny wise and pound foolish." Don't hesitate to spend what could be a couple of $1,000s in the face of tens of thousands of dollars on the backside. So, Mark
And just
Furman,
also
yeah.
assume that this blow up of this text is going to be read by a judge and a jury, as well as the other side. And so it's sometimes helpful to have a third party, a lawyer, see a draft, make suggestions, and perhaps protect you more.
Always offering up practical advice, always offering up the opportunity to mitigate damages and things down the road. Mark Furman, director and shareholder of Tarlow, Breed, Hart and Rodgers. If people want to reach out to you and talk about how you can mitigate negative circumstances in their businesses or any disputes that they may be on the cusp of, what's the best way for people to reach out to you?
My email is best, Jonathan, M. Furman, Furman, at tbhr-law.com.
Great. Mark, as always, wonderful to hear your tips on entrepreneurship and the law and giving business owners guidance in how to protect themselves. Mark Furman of Tarlow, Breed, Hart Rodgers. It's been a pleasure, as always, seeing you on Radio Entrepreneurs.
Thanks, Jonathan.
And we'll be right back with another segment on Radio Entrepreneurs.